morning, everyone. Welcome to Trademark 101. My name is Pascal Devian, the Member Services Specialist here at JTHS Miami. Please keep yourselves muted. If you have any questions, please put in the chat. Ramya will get to it when she can. And now, of course, I'd like to introduce our instructor, Rami B. Harada, Esquire. Please take it away.
Hi, good morning, everybody. Thank you so much for being here with me today. I'm going to go ahead and start sharing my screen. Today's class is about trademarks, a little bit of copyrights and intellectual property as it relates to the real estate agents. So please feel free to ask me any questions. You can put them in the chat and we'll get started right away. I'm an attorney. I've been doing this for over 13 years. I am based in Miami, but we do help people all over the world when it comes to immigration and intellectual property, all over Florida when it comes to business law, estate planning, probate, and real estate, and also all over the state of Florida when it comes to litigation. So while today's class is focused on trademarks, you can always reach out to us with any questions regarding all of those other areas of law that I've mentioned. So trademarks 101, what do you need to know? We're going to talk about the different types of marks. We're going to talk about the benefits of trademark registration, how to select marks, the requirements for registration, dealing with the trademark examiner, which is basically an attorney that works for the United States Patent and Trademark Office, and registration with U.S. Customs. So first of all, what is a trademark, right? So a trademark can be, you can trademark words, names, phrases, symbols, designs, and even sounds, okay? So it's not just, people think it's just the business name. It's not. It can be any word that describes your business. For example, as it relates to realtors, you may have a team name. It's not your name, it's not your brokerage name, but it's the name of your team and what you want people to remember. So you would want to trademark that team name as it relates to real estate services. It could also be a slogan. Maybe you have a slogan that you use a lot to define your services, to talk about your services, and that's something that you may want to protect so that nobody else all over the United States can use that slogan as it relates to real estate services. It could also be a symbol. Maybe you design something that you don't want, or a logo that you do not want other people to use as it relates to your services. You can protect that too. And you could also protect sounds. Different sounds can be trademarked. So basically, a trademark is something that is used to identify and distinguish goods and services from those provided by others. So that is the goal of the trademark law, is to say this belongs to this person or to this company, and only when this company uses it are we going to allow it. If anybody else uses that word, slogan, logo, sound, name, then we're going to stop them because this other person used it first and protected it as it relates to trademark law. And it indicates the source of goods. That's the most important thing. So whenever somebody sees that logo, sees the slogan, hears that name, you want them to think, okay, this comes from this person or this comes from this company. And that is what trademark law does in essence. We also have something called a service mark, which is basically the same thing as a trademark, but that one is to define services. So this is more for realtors. You're going to have a service mark. Me as an attorney, I'm going to have a service mark because I don't sell any goods. However, that has changed now a lot with people being able to merchandise. So even if you are a realtor and you're only providing real estate services, my advice would be don't just protect the trademark as it relates to real estate services, protect it as it relates to merchandise, to clothing, because you may want to do those, clothing, t-shirts, hats, and you may not want somebody else to do that clothing and then be able to use that name for those products. Because the way that trademark law works is you cannot protect the name in all classes. It doesn't work like that. You can protect the name in the classes that you're either using or you're going to use. So it's important for us when we're working with trademarks to understand what is the client doing right now? What is it that they're selling, right? And then what is it that they plan to sell in the future? For example, we had recently a client that she is a social media influencer. So right now she's selling webinars, she's selling educational activities, she's selling that, right? But eventually she wants to go into merchandise. She wants to sell t-shirts, she wants to sell mugs, she wants to sell all these other things with her name on it. So for now, we protected her service, which is that providing educational material as it relates to makeup, because that's what she's doing right now. But then we said we have the intent to merchandise, do mugs, do this, so that we can protect that too. So even though she's not doing it, nobody else is going to be able to do it because she's saying she has the intention to do it in the future. And then eventually when she does it, which she has to do, then we will convert that to a regular trademark because she's already using it, and then be able to obtain a registration. Some example of service marks, so that you understand what I'm talking about, are, for example, American Airlines, or AA. That's a trademark for airline services. McDonald's, for example, is a trademark for a restaurant service. So what it does, service mark, is basically the same thing as trademarks, except that they identify and distinguish services instead of products. Okay, so basically in real estate, you're going to have a service mark, but it's just a trademark. So what protection is available? The rightful owner of a trademark or service mark can prohibit others from using the same mark or another mark which is so similar in sound, meaning, or appearance that it would likely lead to confusion amongst customers regarding the source of the products or services in connection with which the mark is used. So what does that mean? So for example, I have a client, well, I can't use names, but let me use my name, for example. My name is Romy Jurado. So I trademark my name as it relates to legal services, okay? So nobody else can use Romy Jurado as it relates to legal services. My name is spelled R-O-M-Y, and my last name is spelled Jurado, J-U-R-A-D-O. So that's my trademark, Romy Jurado, my name. Well, my last name means jury in English, right? So imagine somebody else tries to use my name as it relates to legal services with Romy Jury. Can they do it? It sounds different, but it means the same. So they will not be able to do that because trademark law protects not just against the exact words, but the meaning. So since my name means jury in English, if somebody else tries to use my last name in connection with my name, they will not be able to use it for legal services. So no, they cannot use Romy Jury. They can use jury, maybe, but not Romy Jury. Another example, my name is spelled R-O-M-Y. I know a lot of people spell their name R-O-M-I-E, R-O-M-M-E-E-E. They still sound the same. So nobody will be able to use that either because I trademark my name and nobody can use anything that sounds similar, that means the same thing, or that in appearance, it will likely lead to confusion. Okay, so when you have a trademark, you're not just stopping the exact words, you're stopping anybody from using something that means the same or that sounds the same or that in appearance looks similar. This happens a lot when we trademark, for example, trade dress. So certain restaurants, for example, will have a certain color. And you know that when you see that color, let me give you the best example, Tiffany. Tiffany has that nice teal blue color that they've trademarked. So if other jewelry businesses try to use the same color, they're not going to be able to because that is Tiffany's color because they protected that trade dress. This happens a lot in restaurants too, where they protect the colors. So Chili's, for example, you can go to Chili's here, you can go to one in Texas. They're going to have the same color. So they protected those colors so that nobody can use those colors as it relates. And in that, combination, as it relates to restaurant services. So you can protect that too. Colors, names, sounds, and everything as it relates to that. Now, in order for you to obtain this protection, can we just protect anything? No, because the marks must be distinctive, okay? So trademark law only protects distinctive marks. For example, descriptive marks, geographic names, and surnames are not inherently distinctive and can only be protected if they can shown to have attained distinctiveness through the use referred as secondary meaning. So what do I mean by that? If you have a descriptive mark, right? Let's say you cannot trademark apple for apples, right? You cannot trademark Peru, for example, because that's a geographic name. And you cannot trademark last names unless you show that they have obtained distinctive meaning and that they have attained this distinctiveness through use. And this referred to a secondary meaning, then you might be able to protect it. So what are things that we want? We want trademarks or names that are arbitrary, fanciful, and suggestive marks are deemed inherently distinctive. And I'll talk about that in a minute. Generic terms, okay, are unprotectable and can never function as a trademark. For example, restaurant, for trademarking a restaurant, you won't be able to use it. pencil, for trademarking a pencil, you won't be able to use it. So you cannot use things that exactly describe what it is. You can trademark things that suggest what it is, but not that it exactly describes what it is. So what do I mean by distinctiveness? So for distinctiveness, we want something that's arbitrary. So this is when you're thinking of what type of name do I want for my business? What type of slogan do I want to use for my business? Morely, I guess, most for the name. What type of name do I want for my business? What are the qualities that I'm looking in this name? Well, you want something that's arbitrary, use words that are in common use, but bear no relationship to the associated good. For example, Apple for computers. For example, Pandora for selling, real estate services. I know that there is Pandora, the music line, right? You cannot trademark Pandora for selling radio services or music services, but you could trademark Pandora for selling real estate services, because while there is a trademark for Pandora in the other class, it has nothing to do with real estate. Or you can use any word, common word, to describe something other than what the word means. Like here we have Apple for computers. That is, of course, trademark, but you cannot trademark Apple for selling apples. You cannot do that. You also may want to think about a mark or a name that is suggestive. For example, it suggests some quality or character of the associated goods, but not so explicitly that no imagination is needed to determine the nature of the goods. Okay, let me tell you guys that again. So it suggests some quality or character of the associated goods, but not so explicitly that no imagination is needed to determine the nature of the goods. And one example of that is copper tone for sunblock lotion. Copper tone, right? So it's kind of telling you you're going to get a copper tone, but it's not telling you a sunblock. It's suggesting something that you might get for using sunblock. And so that is a trademark, copper tone for sunblock lotion. You also may want to think of a name that is fanciful. And what do I mean by that? I mean composed of coined words, right? So you get two words and you combine them, and then you come up with something new, and that might be something you want to trademark. An example of that is Xerox for photocopiers, right? Those are two words or two different things that were together, and now it's trademark for photocopiers, Xerox for photocopiers. Or Kleenex for Kleenex. Now, you know what happens when a name becomes so well known, sometimes it might lose its trademark protection. Because if people start calling Kleenex, instead of saying, I don't even know how to say Kleenex without saying Kleenex. It's not toilet paper. It's not
Tissue.
paper, tissue. Okay, there you go, tissue, see? But I'm more familiar with Kleenex. So if people start using just one word instead of the other one, it might lose its protection. Descriptive. We don't want marks that are descriptive. Why not? Because you're not going to get trademark protection. So marks that have descriptive qualities, ingredients, or characteristics of the product or the services with which the mark are used. For example, beef and brew for a restaurant. You're not going to be able to protect beef and brew for a restaurant because it's extremely descriptive of what a restaurant is and what it does. And the trademark law cannot protect something that everybody else is using. It has to be something different. We also don't want generic words. We don't want to protect generic words. For example, beer, shoe, automobile, to which a particular product belongs. A generic term can never be a trademark for the identified goods. For example, apple for fruits. But if you add another word, for example, Romy's apple. Okay, can I trademark Romy's apple? Yes, probably you can. Now, what they're going to do is they're going to make me disclaim the word apple for apples, but I'm still going to have the trademark Romy's apple, and nobody's going to be able to use Romy's apple as it relates to apples. I just do not own the word apple, and they're going to make me disclaim that. So that happens a lot. I get clients that come in, for example, they come in with, Miami's Med Spa. And I'm like, no, you cannot trademark Miami's Med Spa. Miami is a geographical term, and Med Spa, it says what it is, a medical spa. So, but I tell them, add another word. What is your name? What are your kids' names? What do you want to call it? How does this place make you feel? Add another word, and you might be able to trademark that. So we cannot do Miami's Med Spa, but maybe we could do Rosie's Med Spa or something like that. Or, you add a word that makes it different and unique, and then you might be able to trademark that, even though the other words basically describe the services. They might make you disclaim the geographical term. They might make you disclaim what it means, but you still might be able to trademark, which is what we want at the end of the day. So what are the benefits of trademark registration? Why go through this exercise? Well, first, to use. In the US, deferral registration is not required to establish rights in a trademark. Rather, common law rights arise from actual use of a mark, whether or not is the subject of federal registration. Generally, the first to use, either the mark in commerce or file an intent to use application with the United States Patent and Trademark Office has the ultimate right to use and register the mark. This is important. Even if you're not using the mark, if you file an intent to use application, you are going to have more rights than somebody else that uses it 2 or 3 months later. You are going to be able to register that mark, not the other person, because you file an intent to use application. That is why when I have meetings with clients, and for example, I represent a lot of chefs, and they're usually trademarking their name as it relates to restaurant services, because that's what they're doing right now. But I tell them, listen, you need to trademark your name as it relates to educational services. You may be teaching cooking classes, as it relates to any type of promotional material. You may be producing plates, mugs, anything like that, as it relates to any cooking utensils. You may come up with your pot line that you may be able to sell. And it's an intent to use that we could actually extend. So you get like up to 3 years of that intent to use. You need to use it within those 3 years, but you can keep on extending for up to 3 years and then say that you still intend to use it. So again, registration is not required, right? Even if the senior user does not have a registration for its mark under Section 43A of the Trademark Act, the senior user generally may stop a junior user that has obtained a federal registration for its mark. However, registration is recommended. Even though registration is not required for trademark protection, it is advisable for a company to obtain registration for its trademarks. So what do I mean a senior user can fight you if you have a registered trademark? Well, you go through a process to obtain the registration of your trademark, right? So this process can take up to a year. First, we file the application. It takes around 3 months to get assigned to a United States Patent and Trademark attorney at the USPTO office. And then they have 3 or 4 months to do a full search to see if it contradicts with any marks. And then after that, it goes to be published in what is called the Gazette, which is the United States Patent and Trademark Office newspaper for the public to see and for the public to object if anybody thinks it's infringing upon their trademark. If nobody objects, then that's it. You get a registered trademark, right? But let's say that somebody was using the mark 2 years ago. They can actually file something to try to revoke your trademark because they were using it before, okay? However, the likelihood of that happening is very slim because that can be very costly. After 10 years of use, then we can file something with the United States Patent and Trademark Office that basically makes your trademark uncontestable. If those people were using it before, but they never filed anything, now they cannot file it anymore because after 10 years of your registration, it becomes uncontestable, okay? So registration, of course, is recommended. I highly recommend it. Registration is the only thing that's going to help you really send somebody a cease and desist anywhere in the United States and say, stop using the trademark as it relates to those services because they conflict with mine. And then they have to stop it. And if they don't, you can sue them, recover attorney's fees and costs, and sue for treble damages. So people will do that. When my clients receive cease and desist letters, my advice most of the time is rebrand. You never trademark. It's in conflict with a registered trademark. There's no point in fighting it if you're going to lose. So it's always good to register. Again, why? Because registration confers important benefits to the trademark owner, such as the possibility of treble damages for infringement, the presumption that the registrant is the owner of the mark, geographic coverage for the whole United States. Even if you're only using it in Florida or New York, you're going to get protection all over the United States, and incontestability after 5 years upon filing the affidavit and after 5 years of continuous use, okay? So 5 or 10 years, incontestability. So I'll give you some examples of clients that have actually helped stop others using their trademark. One of my clients sold financial services, and she had a really catchy name. And then in TikTok, somebody had used her name, but added like a 2 on it. But it was her name, the name that she used for her services. All we had to do is send her a cease and desist letter. She stopped all of the use and she gave her access to her Instagram account because they had a bunch of followers. And that's it. My client was super happy, all because she had a registered trademark. Another case was a salon. Again, they were using her name, her salon name in another state. And my client didn't want that because it was messing up with her Google finding feature. And of course, you have to protect your trademark once you have it. So we sent her a cease and desist letter. And instead, we got back an offer and they said, look, we are in another state. We really like this name. Is it possible that you license to us your trademark? And my client's like, what? I'm like, yeah, you can do that. They're using your name, but if you want, we can do a license agreement. So now you're going to get royalties from whatever they make in that salon. And she agreed, and we did that. She licensed her name out. Now she gets paid every month, all because she had a registered trademark. Another client of mine registered another trademark and somebody wanted to buy it. That business was not giving her a lot of money, but this other person wanted to buy the registered trademark, so she sold it and she made money there. Whenever you want to franchise, if you want to grow your business, you're going to need a registered trademark. Whenever you want to protect your business name so that nobody else is using it, you're going to need a registered trademark. So all of those are the benefits. So the symbols, right? We see this little R that is encompassed by a circle. You can never use this unless you have a registered trademark. Okay, don't forget that. It's illegal. Okay, the R symbol is used by trademark owners to give notice that a particular mark is registered with the United States Patent and Trademark Office for particular goods or services. It may only be used after federal registration has been granted. I have some clients, we file their trademark and then they start using it. And I'm like, no, you're violating the law. If the United States Patent and Trademark Office sees this, they're not going to give you your trademark. You can only use this after you've been given the trademark, okay? So even if the trademark application is pending with the United States Patent and Trademark Office, the R symbol may not be used until the mark becomes federally registered. Improper use of a federal registration symbol, if done with intent to deceive the purchasing public or others in the trade into believing that the mark is registered, is ground for denying registration of an otherwise registrable mark. Okay, so be really careful with that. Now, what can you use? You can use the TM symbol. The TM symbol is used by trademark owners before they obtain a federal registration for their trademark. The use of the TM symbol, while not required by trademark laws, can serve many useful purposes for a trademark owner. It just says that you have common law rights over that trademark, okay? All right, can you mail yourself a letter using your mark as proof of date of use? No. The way that you prove date of use is when you sold your first service or your first product. So you need to sell it. Sell it over the internet, sell it over the mail, sell it. Mailing yourself a letter, it's not proof of use. You need to sell your first product or first sell your first service. So if you're selling real estate, you have your website that says you're selling real estate and using that name to promote your services. Maybe you have cards, you have flyers. You know, when did you first start using? That's how we would show it. Let me see. If someone abandoned a similar name to one I am attempting to trademark, can I file an intent to use registration? Okay, so let's talk about that. Sometimes people file a registration and they get something called an office action to which they have 6 months to respond. If they don't respond, then that is deemed abandoned. And then that's it. That doesn't continue. So if you're going to be using, you find an abandoned trademark and you want to use that for your particular product or service, my recommendation is to do a trademark search. Okay, so we do that. We offer that service. We do a full trademark search to where we give you a legal opinion whether we think that mark is registrable or not. Now, that's not a guarantee. I am not the United States Patent and Trademark Office. That is just based on the research that we've done all over, and we provide all of the material to you so you see what we have searched. And we search in up to 5 classes to see if we think it will be registrable or not. So to the person asking whether they can trademark an abandoned trademark, my advice is let's do the trademark search, and then we can give you a legal opinion to see if it can be done. So what is an office action? Again, an office action is when it's assigned to the United States Patent and Trademark Attorney, and then the trademark attorney says, for any reason, you know, the likelihood of confusion, it's not inherently different, or we have another trademark, they come up and give us a response to say to us, you cannot register this because of this and that. So then we need to come back and argue to them that we should register. And what do we use to argue to them that we should register? We use what is called the DuPont factors. So there was a case in the United States Supreme Court that came up with these 13 factors that we should analyze as attorneys and argue in order to say that it will not create the likelihood of confusion with another mark, and our brand or our mark should go forward. So for example, we have 1, the similarity or dissimilarity of the marks in their entireties as they appear, sound, connote, and commercial impression. So we argue that. The similarity or dissimilarity of the goods for which the marks are used. Are they really the exact goods, or are they somehow different to which our mark should still go forward? The similarity of the channels of trade of the goods for which the marks are used. And this is a cool one that I've actually used successfully. So we had a client, we were trademarking a name for his store where he sold high-end bridal gowns. High-end, I mean, like, wow. So he had a store where he sold high-end bridal gowns. And the USPTO office came back to us and said, no, we cannot register this because there is a trademark for another brand of used bridal gowns. Used bridal gowns, okay? They were in the business of basically people will use them and they would get them and rent it to people. So they were renting bridal gowns. You would think it's the same, right? So there are bridal gowns here, bridal gowns here. It's not. Why not? Because the channels of commerce to where the people here that are going to buy these high-end bridal gowns, it's not the same channel of commerce of the people that are renting used bridal gowns. Also, there is another part here which talks about how the sophistication, number 4, the sophistication of the purchasers, impulse buying versus careful, sophisticated purchasing. That's another thing that we argue. That's customers that are going to buy this really expensive gown, they're not going to buy it on impulse. They're going to be really thinking about it. You know, it's sophisticated customers, and they're not going to go and buy and rent used gowns. These are different types of consumers. These are different channels of trade, and therefore both brands can coexist without causing the likelihood of confusion. So these are the things that we would use to argue depending on what the trademark attorney comes back with, the USPTO attorney. Also, the fame of the senior mark, the number or nature of similar marks in use or similar goods. That's another cool one, because if the name they don't want us to use is because they're saying it's conflicting with just this mark, but then we found that the same name in connection with other words is being used for other marks that sell the similar products, then they should allow ours too. So that's another argument that can be made. Then the nature and extent of any actual confusion, the length of time under which there has been concurrent use without evidence of actual confusion, the variety of the goods on which the marks is used. Again, we continue with the DuPont factors. We have the market interface between the junior and the senior users, the extent to which the applicant has the right to exclude others from use of its marks on goods, the strength of the mark, the extent of potential confusion, and any other established fact probative of the effect of use. We don't deal with this until the United States Patent and Trademark Office has issued us an office action. And it is so important. I hope you use me for your trademark, but whoever you use, don't get scared if you get an office action and that's it, I'm done with this trademark, because there are ways to fight it. Like I mentioned to you, you know, we can really analyze. Sometimes we even get opinions of experts in the industry. Okay, for that bridal gown situation, we got the opinion of a professor of fashion, you know, and her opinion was valuable because they can talk about the market and the distinctiveness and this and the other. So just because you have a trademark that you filed and you get an office action, don't give up. You may still be able to register it, okay? Sometimes the United States Patent and Trademark attorneys can be very arbitrary and just issue an office action for no reason. Sometimes they do have some, meaning to it. It all depends. We need to analyze it. So what are some measures that we can take to avoid infringing on marks and to make sure that we have an availability to trademark a name? Is called a trademark clearance search. And that is something that we can do. We do a full trademark search. We search both registered and unregistered uses. Of course, nothing is perfect, but it's going to really help you because it's going to give you an idea and an opinion from us saying, yes, you should be able to register, or no, you better think of something else. Who should be doing trademark searches? Everybody that's selling a product or service. Because what you don't want is that you invest so much money on this mark, you bought a bunch of materials, you bought the website, You have your Instagram, Facebook, TikTok, all these followers, everything in between. And now you get a letter, a cease and desist letter that says, stop using or I'm going to sue you. And then you have to stop. You definitely don't want that. So anybody that's starting a business, please do a full trademark search so that you know that you're able to register that trademark, and please file your trademark. So that's the only way to protect your name. A lot of people erroneously think, oh, Rami, but I registered my name in the Florida Department of State. It's in Sunbiz. I have my company. Nobody can use that company name. Incorrect. Somebody can form that same company name in any other of the states. The same exact name. They can have the same company name. Oh, but nobody can use that name in Florida. Also incorrect. I can go and file a DBA, doing business as fictitious name, and do business in that same name as your company name, selling the exact same services and having my office right next to yours. And there's nothing you can do about it unless you have a registered trademark. So registering a name in the Florida Department of State or in any Secretary of State, forming a company, does not give you protection. Also, finding a DBA, doing business as fictitious name, does not give you any protection. Only registering a trademark stops others from using that name as it relates to any product or service that is protected. So use of mark required for registration. So while we can file an intent to use, we are not going to be able to get the actual registration until we're actually using it. So assuming the mark is capable of registration, the mark ultimately must be used in commerce before the United States Patent and Trademark Office will issue a registration. Use in commerce is defined as all commerce which may be lawfully regulated by Congress. This typically includes commerce between states and commerce between United States and a foreign country. That is why you need to sell to another country, you need to sell within the United States. Sales of goods across state borders or into the United States from a foreign country will constitute use in commerce, okay? And then we have two registration paths. We have the principal register and the supplemental register. We, of course, want the principal register. So two main paths to registration on the principal register. Use-based applications. So these are the applications when you're using the product, or I'm sorry, the mark. A person or company who already has used the mark in commerce may file an application based on this use. Intent to use, that is the one that I mentioned before, application, is a person or company who has a bona fide intention to use the mark may file an application upon this intention to use the mark. A registration will not be issued until the applicant has begun to use the mark. However, the examination starts. So it goes through the same process. We will know if there's an office action or no, because it goes through the same process until you actually use the mark and you get the registration. The initial review of both use-based and intent to use applications will be, I would say, within the first 6 months. If it complies with statutory requirements, and also to see if there's any grounds for rejecting it. If there isn't, okay, then if it's intent to use, the United States Trademark Office are going to give you what is called notice of allowance, and then we'll know we can register once we start using it. And if it's already being used in commerce, they're going to send it to be able to be published in the Gazette, in this newspaper of the government, to see if anybody objects to it. If the United States Patent and Trademark Office issues an office action, the applicant may respond through an attorney with argument as to why the mark is registrable. A response is due within 6 months from the date of the office action, and for that, we will use the DuPont factors that I mentioned earlier. If the response is unsuccessful, the rejection is generally deemed to be final in a second office action. Generally, because sometimes they just want clarification and then we can answer again. It is possible to file a request for reconsideration within 6 months and/or appeal. We can also do that as well. Effect of acceptance, publication for opposition. Publication in the Official Gazette of Trademarks. There is a 30-day opposition period for interested parties, subject to extensions up to 120 days from the publication date. If opposed, opposition proceeding in the Trademark Trial and Appeal Board will determine applicant's right to register the mark. So far, we haven't received any oppositions, but it's always possible. Effect of successful passing through publication stage. So you will get a registration certificate if you were using the mark. Intent to use applications, okay, you need to file what is called an amendment to alleged use, and then it will be they will be published, and then you'll be able to get the mark. Notice of allowance issues for ITU applications. For intent to use applications, they will get a notice of allowance if you haven't used it yet. And again, you have to extend this every 6 months if you're still not using it for a maximum of up to 3 years. So renewals, section 9, renewal and application with declaration of continued use must be filed every 10 years after the date of registration. There's of course filing fees per class. We have to provide specimens. So once you get the trademark, it's not forever. You have to continue using it in order to keep it, right? If you stop using it, then you won't be able to re-register or renew it. So these are some objections that we might get from the United States Patent and Trademark Office. For example, they might say that identification is unclear, it needs to be clarified, and then what we will do, which is a friendlier way, is we will actually call the examiner and ask them what clarification, or ask her, maybe they want a special ID, maybe they want something. We deal with them to try to clarify it so that it's not a big deal and it can go forward, faster. This one, when we get a response that has likelihood of confusion, then there we really need to evaluate, maybe narrow down the goods and services, think about how marks can be distinguished, different components, sounds, meanings. We have to argue that the goods and services are unrelated, look at the DuPont factors, maybe argue that customers are sophisticated and they will know one mark from the other. All of these things we will do once we get the office action. It's not like you can argue this when presenting the mark, you have to wait. Okay. So let's say that we got the mark registered and you're selling purses. Well, that's not all. Yes, now you have the mark. Nobody in the United States can sell goods, purses with that mark. But you also want to stop people from bringing in counterfeiting products from other countries into the United States. That is so important for products, for purses, any type of product, because everything can be done outside of the United States. They stick your tag on it, bring it here, and now you're losing that market. So imports of goods marked with infringing trademarks can be barred by U.S. Customs and Border Protection. Under the Lanham Act, no article of imported merchandise shall be admitted to entry at any U.S. Custom house if it copies or simulates a trademark registered in the United States, copies or simulates the name of any domestic manufacturing or foreign manufacturer that treaty, convention, or law affords similar privileges to U.S. citizens of the United States, bears a name or mark calculated to induce the public to believe that the article is manufactured in the United States or that is manufactured in any foreign country other than the country in which it's in fact manufactured. So the one we are going to focus on, no product should be imported to the United States that copies or simulates a trademark registered in the United States. And how do we stop that? Well, once you have your registered trademark, you need to file with customs, okay? You need to file the intellectual property rights e-recordation, okay? Which will include the name, address, and citizenship of the trademark owner, the name and address of foreign persons or business authorized or licensed to use a trademark, right? Because you may have authorized some people to bring in those products, so you want to give that name to U.S. Customs. You want to include the copy of the registration, which is the certificate, and of course, the filing fee of $350 for each class or goods or services in the trademark. All of this you would send to the U.S. Customs, and you would file it. Of course, in real life, you have to make sure that you're on top of them. And if you know that there are specific countries, specific people, specific companies that are bringing in products, then you want to let them know. You want to make sure that you're on top of them so that you stop this infringing use from other companies bringing in, basically their products with your trademark on them that you fought so hard to obtain. So I do advise to register with customs if you're selling products, and I also advise to be on top of them and provide as much information as you can, and they will be helpful in stopping the counterfeiting of your products. So here is some information about our firm and how we can help you. I don't see any questions yet, but please feel free to put them there. We can help you, of course, with company formation, nonprofit organization, any type of business domestication for people that form in other states and they want to make it a Florida company, a Florida LLC, company dissolution, any type of licenses, permits, any type of document drafting, buying and selling businesses. We do all of the documents and we do the closing, of course, trademark registration, copyrights, investment visas, real estate, state planning, trust wills, probate, name changes, litigation, and we also do timeshare cancellations. Here is our contact information. That's my beautiful team. You could always feel free to reach out to us. Anytime you have any questions, we always try to be a helpful assistance to realtors. I know you guys deal with a lot of people and a lot of issues. So if there's anything that we can do for help, please feel free to reach out. Okay. How costly or time consuming can an action be if someone infringing ignores a cease and desist? What is the process beyond the cease and desist? This is a great question. A lot of attorneys will take a trademark case where somebody is infringing upon your registered trademark on contingency basis. Why? Because they know that they can get treble damages and they know that they can get attorney's fees and costs. Okay. But they are only going to do this if you have a registered trademark. So if you have a registered trademark and you need to police your trademark and you see another company or people using your trademark as it relates to those goods or services, feel free to reach out to us because we may be able to take it on contingency basis, or another attorney may be able to take it on contingency basis depending on where it is and how much work it's involved. And they will do this because once you have the registered trademark, you get treble damages and you also get attorney's fees and costs. As long as you can show you have a registered trademark and this other one causes a likelihood of confusion, and you sent them the cease and desist letter to show that you told them, hey, you need to stop, and they continued, then you will be able to do this. Well, I hope this has been helpful. It's a real pleasure to give you guys as much education as I can. Again, feel free to reach out to me. My contact information is in the chat, and I look forward to our next class. Thank you so much.